Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Prakash Chan vs. Income Tax Officer, pronounced by Delhi Tribunal on the 19th of May 2026. The assessee, Mr. Prakash Chan Agrawal, filed his return of income for assessment year 2017-18. The assessing officer completed a scrutiny assessment under Section 143(3) of the Income Tax Act, examining all relevant facts and details. Subsequently, the AO initiated reassessment proceedings under Section 147 by issuing a notice under Section 148. The reasons recorded alleged that income had escaped assessment due to the assessee's failure to disclose fully and truly all material facts. The reassessment order was passed, leading to an addition of income. Aggrieved, the assessee appealed before the ITAT, challenging the validity of the reassessment proceedings. The ITAT emphasized that the power to reassess under Section 147 is not unfettered. It can be exercised only if the AO has reason to believe that income has escaped assessment, based on tangible, objective material, not mere subjective suspicion. The core of the ITAT's reasoning revolved around the doctrine of change of opinion. The tribunal held that once an assessment is completed under Section 143(3), the AO cannot reopen merely because he has a different view on the same set of facts already examined. The ITAT relied on the Supreme Court decision in CIT vs. Kelvinator of India Limited, which categorically held that the law does not permit reopening on a change of opinion. The reasons recorded did not indicate any new material or failure by the assessee. The ITAT analyzed whether the assessee failed to disclose material facts. The tribunal observed that the AO's reasons did not establish any failure. The original assessment under Section 143(3) had already examined all relevant facts. The ITAT held that the AO cannot use reassessment to re-examine the same facts already considered and decided. The absence of any new tangible material or specific failure to disclose facts rendered the reassessment proceedings invalid. Based on the above reasoning, the ITAT concluded that the reassessment proceedings were initiated without jurisdiction. The notice under Section 148 and the subsequent reassessment order were set aside. The appeal was allowed. The ITAT Delhi bench's decision reaffirms that a mere change of opinion cannot justify reopening a concluded scrutiny assessment. The ruling provides clarity and protection to assessees against arbitrary reassessment actions. Question: what is the main legal principle established in this case? Answer: the main principle is that reassessment under Section 147 cannot be initiated based on a mere change of opinion. If the original assessment was completed under Section 143(3), after scrutiny, the assessing officer cannot reopen the assessment unless there is fresh tangible material or a clear failure by the assessee to disclose all material facts. Question: what is the significance of the Supreme Court's decision in CIT vs. Kelvinator of India Limited in this context? Answer: the ITAT relied on the Kelvinator decision, which holds that the law does not permit reopening of an assessment on a change of opinion. This case reinforces that principle, making it clear that the revenue cannot use reassessment to review or revise its own earlier conclusions. Question: what was the outcome of the appeal for Mr. Prakash Chan Agrawal? Answer: the ITAT allowed the appeal, quashing the reassessment proceedings initiated under Section 147. The notice under Section 148 and the subsequent reassessment order were set aside, providing complete relief to the assessee. Question: what must the assessing officer establish to validly initiate reassessment under Section 147? Answer. The assessing officer must have reason to believe that income has escaped assessment. This belief must be based on tangible, objective material. Additionally, if the original assessment was under Section 143(3), the officer must also establish that the escapement was due to the assessee's failure to disclose fully and truly all material facts. Question. Does this decision apply to all reassessment cases? Answer. This decision applies specifically to cases where the original assessment was completed under Section 143(3) after scrutiny. It reinforces the principle that reassessment cannot be a tool for a second opinion on the same set of facts. However, each case is fact-specific, and the presence of new material or a clear failure to disclose facts could justify reopening. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.